Let me start out by thanking Chris Hamilton and everyone for the opportunity to be here today. It's always my pleasure to come here and really talk about what's going on the front lines in the battle against the Obama administration as they try to severely limit the use of coal in the United States. Unfortunately, we know that we have a president that will literally stop at nothing to severely restrict the use of coal here in West Virginia. And we know that that not only has a very negative effect on coal, but it has a very negative effect on everyone here in this room and all of your families. I look out at all of you and I see the backbone of our state. West Virginia was built on coal, and I never forget that every day that I go into my office. So I want to thank you for all that you do for the state of West Virginia and for all the work involved in keeping the lights on. Now, as Chris indicated, for the past 2.5 years, we've been really focused on ways that we can push back against this administration. We've fundamentally changed the office so that finally you have a West Virginia AG's office that speaks out on behalf of the people of the state of West Virginia. Do you all remember when people said that the Attorney General wasn't allowed to file lawsuits against the EPA? How absurd was that? Well, now we've been working to build large multi-state coalitions in order to apply a great deal of pressure against the EPA. And I think that our work is beginning to bear fruit. And I'm going to talk a bit about some of the pieces of litigation that we're involved in. But I, for one, despite some of the tough news that we've seen recently, I see a very bright future for coal in the state of West Virginia. And I know that some of the legal battles that we've been engaged in, I think will pay off over the course of the next 1.5 years. So let's start and talk a little bit about some of that litigation. I think many of you know that we've been working with a 15-state coalition to take on the administration's Clean Power Plan. Now, about 1 year ago or so, after the initial proposed rule came out, our office, along with a number of others, stepped up and filed a lawsuit. Now, this was not a typical lawsuit. We filed it while the rule was still in its proposed state. Now, a lot of people suggested and said, well, this is unusual, Mr. Attorney General. Why did you do that? We did it because we saw that the harm from the proposed rule was occurring right now in the state of West Virginia. We know that there's a great deal of pressure on power plants to move away from coal toward other forms of energy. We also know that there are severe layoffs that are occurring, and at least part of the reason is due to this constrained regulatory culture flowing out of Washington. So we went in early because we thought that the circumstances warranted it, that the harm was happening now, and if we didn't step up to fight for our people, then there would be adverse results. Now today, we heard back from the D.C. Circuit, and we did not get the immediate result that we wanted, but we're encouraged with the long-term prospects. We knew that there were some uphill fights with respect to winning on the procedural front now, but I think we've been able to tease out a lot of substance from the EPA, and we still have an excellent chance on the merits to defeat this Clean Power Plant rule in court. And that's a big part of the message that I'd like to convey to you today. We will ultimately win this legal fight. You know, there's never a guarantee in life, but I feel very good that we have a 70% chance of ultimately prevailing. Because the legal theories that the EPA has put forth with respect to this rule are really outrageous and unprecedented. That's one of the reasons why we went in and sued while the rule was in a proposed state, because the administration's positions were so tenuous. Now, the court has indicated that it was not going to say anything on the merits, so that gives us the opportunity to go back when the rule is finalized. And I do think that provides us with a real opportunity to prevail. And the psyche here is very important for our state, because we see the articles about 1,800 coal mining jobs being put at risk. We know that power plants are beginning to move over because they fear that ultimately it's a matter of when, not if. I would beg to differ with that analysis. I think that there is a good chance, but we have to hold the line. And when I hear people talking about HB 2004 and the SIP bill, the state implementation plan that we may file, I think you have to really praise what this legislature did to give the state of West Virginia additional tools so we can fight more effectively in court. And we were pleased to help. We were deeply involved in the drafting of that legislation. Why were we? We think it's absolutely essential that West Virginia hold the line and perhaps force the federal government to try to impose these standards on our state. If, in fact, they go down that pathway, they will open up the door to a whole bevy of new legal arguments that we can use. Because it is very clear in constitutional law, you cannot commandeer a state to effectuate federal will. And we certainly are going to step up to ensure that that never happens in the state of West Virginia. Now, the reason why we're optimistic in our office is because we do think that this rule is unprecedented. And I do want to convey that sense of hope. Think about it for just a few minutes. Just a few years ago, this administration already issued a major rule governing coal-fired power plants. You're probably all familiar with that and the over $9 billion worth of cost associated with the industry. What they're trying to do here, though, is to go much further. They're looking to put in place a state-by-state emission target so that we could see reductions of approximately 30% on average over a 15-year period. Now, what's wrong with that? What's wrong with that is that the Clean Air Act does not permit double regulation of coal-fired power plants. And that's a sensible concept because when Congress was drafting this, they envisioned a role for cooperative federalism, a role for the federal government, a role for the state government. What this EPA has done is go far beyond its boundaries in an effort to, in fact, rely on a legal technicality to put in this most sweeping energy policy we've seen in our lifetime. In fact, interestingly, if you read the literal text of the Clean Air Act, the administration's proposal would be prohibited, and the EPA, in fact, says so. So they've had to come up with some significant legal gymnastics in order to advance their approach. So we think that that's one real area of vulnerability. You cannot double regulate coal-fired power plants. What else? Well, anyone who's been experienced with the Clean Air Act knows that the Clean Air Act typically regulates sources, coal-fired power plants, oil and natural gas plants, but you typically don't regulate the entire field in energy. And what this proposed regulation would do is it would not only regulate the coal-fired power plants, but it would try to incentivize movement toward oil and natural gas and toward renewables, water, solar, wind. That's not contained within the Clean Air Act, which is really limited toward regulating coal-fired power plants and other source categories. So we think they've really stretched here. But it gets even worse. This EPA is also trying to influence consumer demand for energy. And part of their plan, in order to reduce carbon emissions by a de minimis amount, I would add, is that they're trying to influence consumer demand. Now think about that for just a minute. If you were the EPA and you were regulating the auto emission industry, this proposal would be akin to saying that people have to buy electric cars or take the bus to go to work, all because it would help reduce auto emissions. Well, that's what they're looking to do here for the Clean Power Plant rule as well. They're open to putting new provisions in place which will regulate consumers' behavior. This is a proposed rule that will literally regulate from plant to plug. It's going to have a sweeping impact on everyone's life. And that's why I think it's so important for all of us to stand together and fight against this illegal rule. So we have a lot of good legal arguments. We have the double regulation of coal-fired power plants issue. We have this question of whether you can regulate outside the fence, outside the coal-fired power plant. But we also have another compelling one. And this gets back to what Chris Hamilton and Bill Cole and others talked about a little bit earlier. This past session, this legislature focused on ways that we could provide another check security in the system. So we just don't allow the federal government to have a blank check on what it's going to do with our state's energy portfolio. So I'm very pleased that the legislature will get to decide whether it will submit a state implementation plan or whether it will force the feds to try to come in and direct West Virginia what to do. Now, the reason why that's so important is because the constitutional law is in fact clear. You cannot simply step in and direct the state to reorder their electricity portfolios. It's not allowed. And so we think that as this goes on, and if the federal government continues to press forward, we will have additional legal arguments to beat back this unprecedented rule. Now, for those who don't know me very well, you may realize that I was a healthcare lawyer in a prior life, and I was involved in the legal challenges to Obamacare. Think of this rule as Obamacare for the energy industry. It is a real problem, but that's why you're going to have an attorney general on point, fighting it every step of the way. Now, what's the timeline for some of the initiatives related to the Clean Power Plan? Well, obviously, we had the court decision today based solely on procedural grounds, but I think we have now an opportunity to go back and to refile or ultimately step in and ensure that there's a stay that's put in place when the rule's finalized. What else is happening? Well, the Supreme Court's going to be ruling on a related case, Matt's case, pertaining to mercury toward the latter part of June. Then we know that the EPA is talking about finalizing the Clean Power Plan rule sometime in August or September. So I think as you look at the timeline, West Virginia is going to be poised to take on any final rule over the course of the next 3 or 4 months. Now, I certainly would have preferred that we would have been able to obtain an earlier victory because the stakes are certainly very high. But we knew the challenges when we entered the fray, and I think it's paid dividends. We are well positioned to advance when this rule is finalized. And here's some other good news. We have a growing coalition of states who are working with us. Right now, we have 15 states who are locked in with West Virginia and who agree that there are tremendous legal deficiencies with this proposed rule. It's my expectation that the number of states that we have will grow and grow and grow. We're likely to move up from 15, hopefully to 20 or 25. And the reason why the number of states are growing is because I think people realize that this administration really has gone too far. They've stepped over the line from a legal perspective and certainly from a policy perspective. I don't know that anyone could really doubt the policy implications of this rule. You think about it from a reliability perspective. West Virginia currently produces more coal than any other state but one. And 40% of the nation's electricity capacity fall to the coal industry. How on earth do we expect to replace that easily under this proposed rule framework? We're not going to be able to. And so I don't think it's a realistic plan. Second, imagine that you have to retire dozens of coal-fired power plants before the baseline expiration. What do? You build new non-coal-fired power plants. What happens in that context? Well, you have to expend money. Who pays the bill? Consumers, ratepayers will foot the bill. That's obviously not something that West Virginia needs when we're already struggling economically. So I think there are a lot of problems with this rule from a policy perspective, and all it will take is for us to come together, to unite, get the word out, not only to fellow coal-producing states, but to non-energy producing states as well, because the policy impact is going to be severe. So I'm pleased to come here today and talk about some of these issues. We have a lot on our plate in the Office of Attorney General pertaining to EPA matters. We've been focused fully on the Clean Power Plan legal battles, but we're also about to enter another battle. Many may know that just last week, the EPA issued another final rule pertaining to the waters of the United States. Is everyone familiar with that? Show of hands. Yeah, it looks like most people are. This rule, and this is ripe for challenge now, could have a significant impact on farmers, on landowners, on coal companies, oil and natural gas, retail establishments, contractors, home builders, those who care about public works projects. So West Virginia is now working with a coalition of states, and we are contemplating filing suit over the course of the next few weeks on that proposal as well. Isn't it nice that West Virginia is now leading these fights against the EPA when before you didn't have much of a voice in the state? And I'm really pleased with the opportunity to work with a state legislature who's really been a terrific partner on these coal-related matters, and I think we're just beginning to take the fight to this administration. So I'm always appreciative of the opportunity to come here today and update folks on the war on the front lines against the Obama administration. Keep the faith. We are going to prevail. It is just a matter of time. Thank you very much.